Good morning. My name is Helen Yoon. I'm with the ACC board. And first, we want to thank our sponsors, Perkins Coie, for this session. And I'd like to introduce you to your next speaker, April Goff. She's a partner at Perkins Coie, and she helps companies leverage their employee benefits plans to attract and retain the best talent. Her experience both in-house and in private practice enables her to negotiate the full life cycle of employment for C-suite and other high-level executives. We're talking about employee privacy today, so I want to mention that her knowledge of cybersecurity and data privacy is vital in her work with clients, and she is a certified information privacy professional. And she advises companies on legislative developments affecting data privacy and security, as well as best practices in data breach and incident response strategies. And she's also a former ACC board member. So please help me welcome April.
Well, thank you, Helen. And it's so good to see so many smiling, familiar faces. And for those of you who don't know, this is by far the best organization you can be involved with in-house. And I say that as a former board member, that the resources you have through ACC are phenomenal. And I'm proud to be part of that now. So as Helen mentioned, I have sort of a strange practice. I grew up as sort of an ERISA practitioner and doing labor and employment on the side and always doing healthcare privacy and Hipaa work. And it's transitioned over the years as cybersecurity and data privacy has become more prevalent, that now my practice is predominantly cybersecurity and data privacy, but with a touch of still labor and employment and benefits work, which has been sort of a strange practice until COVID happened. And when COVID happened, all of a sudden this became incredibly important because so many companies were trying to figure out how do we deal with employee privacy? And I hate this phrase, but it really is where we are, this new normal, because our transition to where we are in the workplace, how our employees work together is so incredibly different than it was a couple of years ago. So 3 years ago, there's a study that the Department of Labor does, and only 17% of US civilian workers actually had remote working at all. And of those that did, it was predominantly white collar managers, and it's sort of a occasional thing. So I was in-house at JCPenney. Our remote work was you could have 1 day a month, and you had to approve that 2 weeks in advance, and that's how we did it. Now, obviously, after moving in-house, this is one of those situations where we went remote as an entire law firm within about a week. And we stayed remote. We're just now getting back to the office. So just as a show of hands, how many of you are back to work? Okay, so quite a few. Is it a hybrid workforce? Yeah, I see a lot of nods. Okay, so you've got a situation now where the employees are working at home and at the office, and you're trying to track potentially some of the issues that dealing with the employees and the privacy, using the computer systems at home and those kind of issues. So that's what we're going to talk about. I'd be happy to provide the slides as well and some tips for you about as a practical matter. And this is something that having been formerly in-house, one of the things that frustrates me the most about outside counsel is they have great legal theories. Great legal theories don't work in the business. We need something that's practical and then actually gets stuff done. Don't have time for memos. We're going to get bullet points. So what I'm going to talk to you about are those practicalities of employee privacy. So obviously there are a lot of complications with the remote workforce. At the beginning, employers were really great about let's ship en masse laptops and cameras and all of the equipment that our employees need. And you did that to be able to stay in business for employers that were lucky enough to be able to use a remote environment. And then there came a situation where it's like, okay, we've got this now, this sort of a steady state. We've got our employees, all the equipment that they need, but we now need to start thinking about how is this impacting culture? How is this impacting the privacy of our employer secrets? How are we able to manage and look at and monitor performance of employees? There's also obviously issues with privacy with vaccination status. I do a lot of healthcare work. I can assure you that as an employer, you can ask for proof of vaccination status from your employees. It's amazing to me that they're like, well, this is a Hipaa violation. No, it's not. It has nothing to do with that. You are absolutely entitled to do so. Now, what you can't do, and I want you to be careful of, the EEOC does not like this, is you cannot disclose vaccination status of your employees to your vendors, or if you have customers that you're having to visit. They can ask for it, but right now it's best as an employer that you not provide that directly to the vendors. And then there's situations that happen where I got COVID, and it was one of those situations. I was very sick, and my employer was like, can we disclose this to clients that you're going to be out because you're in the hospital? Well, that depends. There's a lot of complexity around that. And I would say, as a practical matter, disclosures of illness or treatment, as a general matter for your employees, it's best not to disclose. You can say that the individual is out, that they're taking care of some personal matters, but you never want to disclose the practicalities or the details of that. So, like I said, I want to give you some tips about what's really practical for employee privacy. And specifically, we're going to talk about monitoring employees and surveilling employees. And a lot of times we don't think about big brother type of surveillance, but it's looking to see, like, are they actually at work? If you have hourly employees and they're working from home, how many hours are they actually working? Looking to see, are they actually participating in employee meetings that they need to be? So the first thing is you need to consider whether the employer has a legitimate business purpose for the employee monitoring. Sometimes people want data that you don't really need. And that's something, as a data privacy attorney, I'll tell you, is amassing data for data's sake is not helpful. What you need to be able to do is amass data that actually serves a purpose for you, and only keep it for as long as you need it. Now, there's a lot of sort of spyware type stuff that employers have started using, sort of babysitting type of software, because of COVID, that you can actually take flashpoints of the employee's desktop up to once a second, and you can see what they're doing. Now, I don't know about the rest of you. I check my bank balance. I do other stuff while I'm working. This is not 100% where I'm just doing employer work the entire day. If my employer was being able to see my desktop and see what I was doing, throughout the day, all the time, that's kind of problematic, because what do you really need that data for? What you really want is to see, are your employees being productive? Are they doing what they're supposed to do? You don't need to see that insight into their life. There are also programs where you can remotely trigger camera settings and see if your employee is actually at their desk remotely. From a privacy standpoint, you can imagine this is a cluster. This is not something that I would advise. I have unintentionally seen people make faux pas and been in their boxer shorts on video calls where they accidentally get up. To have employees cameras remotely, you're going to see things you don't need to see. Let's put it real. And there's really no need for that. When you think about it as an employer, you don't want to be known as some sort of totalitarian, just spying on your employees. That doesn't engender a good culture. How many of you have a remote workplace policy that talks about what type of software you can use, your hardware? I see a couple of hands. Okay, if you do, you're going to need to look at that in light of the changes that we've had with COVID and see if it's still relevant and see if it needs to be updated. Is anybody in the healthcare space or deal with protected health information? Okay, I see one or two hands. For those individuals, having protected health information under Hipaa and your employees being able to access it remotely and working from home or Starbucks or something like that is another issue you're going to want to make sure that you're doing to protect that information. Or if you're a financial institution, the type of information you would have about your clients, like mortgage brokers or something like that, that you want to make sure that you have parameters in place about how they can access that information. You need a comprehensive communication and technology plan. So those remote workplace plans that you have, that is not an HR issue. It's not an IT issue. It's not a general counsel issue. This needs to be something that's cross-functional across groups, so you actually have the ability to do something that's legal, that makes sense from a financial perspective, and that also is something that from a technology perspective, you're actually keeping up to date on what needs to be done. Avoiding lifestyle law violations. We'll talk about those later, but these are laws that are on the books and in a lot of places that prohibit you as an employer from taking adverse employment action for an employee doing something off the clock that they might want to do. A lot of times what we'll see with this are Facebook posts, Twitter, those kind of things where someone has said something and the employer gets all up in arms about, and we'll go over what you can and can't do in that situation. Is anybody in a unionized workforce? A couple? Okay. And there's only a few, but what I'll say is even if you're not, you have to be very wary of this. The National Labor Relations Act has some specific provisions regarding surveilling employees that apply even if you're not unionized. And a lot of employers are like, hey, I'm not unionized, this isn't relevant to me, but it is. So let's see. GPS monitoring. Does anybody actually use GPS monitoring, like drivers, trucks, couple? Okay. For those navigation systems and having an employer policy in place, you have to, I represent Uber, and obviously they're tracking people everywhere. They have to for both their own their employee safety and also the safety of the guests. or consumers. For GPS devices placed in company cars, it's probably fine. If you're putting GPS devices into employee cars, it becomes a little bit more of a tricky issue, and you want to make sure that you've got some documentation in place to make sure that the employees are consenting to this. And the other thing is to think about if they're doing it and you're tracking it for employee time or they're doing on their own, is that something that, again, is relevant as a data point? Do you need to know that they're going to their girlfriend's house, or they're going to church, or they're going to get coffee, or whatever it is? If they're not on company time, you really don't. So you need a mechanism to be able to disable that GPS tracking for non-employee functions. Company provided smartphones or mobile phones. How many people have company provided devices right now that you use? Yeah, a lot of us. This is my firm's phone. Those policies need to be up to date to make sure that as an employer, if somebody leaves, that you can get any employer information from those devices, that you can wipe them potentially. And a lot of times people will balk and say, hey, I've got pictures on here, and maybe I've got some pictures you don't want to see on here, or text messages or something else. Obviously you need to have something in the culture or in the policy that says that, you know, you are going to use this for non-discriminatory purposes. You're not going to do anything that's going to engage in illegal activity. And sorry, we as the employer have the right to review this, take a copy of it, and maybe we need to save it for legal retention purposes. So when you're looking at it, really, there are some arguments that, well, this is my own device. It's not a company device. You're not entitled to it. But if you have a policy in place that says that you can search it, that you can take information from it, it doesn't matter who owns the property. What matters really is the consent. And a lot of times you'll need to put that into your onboarding and make sure that it's rolled into that way. So GPS and those kind of things, you know, there's a difference between employee safety and security, customer security, and you're really looking to see, like, are employer resources being used appropriately? And this is sort of the fundamental aspect of data security, is really data hygiene. What is the minimum level of detail on data that needs to be tracked? And is this something for business use or personal use? And is this going to be something that is potentially going to trigger an invasion of privacy claim for an unfair labor practice? The biggest issue that you have, and if you take nothing else from this, is I want you to go back and look at your policies and say, you have no expectation of privacy with respect to any employer device or any employer actions or anything that you're doing on computer that it belongs to the employer. And that means personal matters, personal email, everything else. You need to have that expectation of privacy eliminated, because really, and that sounds kind of creepy to say, but as the employer, you want to be able to reach into everything that they have personally that they're doing on their own stuff, but you have to do it the right way. So lifestyle laws, these laws really came about late 90s, early 2000s, and it was an employee benefits issue that triggered it. A lot of employers had a situation where they were trying to raise the healthcare costs for smokers. They said, you know, if you have COPD, if you have something like that, that's raising the cost of healthcare, we want to say, if you're a smoker, you're going to pay a surcharge, or we're just not even going to hire you. Scott's, the company that does, you know, the grass fertilizer, they had a policy in place that they would not hire smokers. And there was a pushback from people that said, you know what, that's really none of your business as to whether I smoke. And it became sort of a groundswell that led to legislation that said that, you know what, if you smoke, if you drink on your own time, if you're using consumable goods, which has been interesting as things have changed with legalization of marijuana in a number of states, that you can't fire employees under these lifestyle laws for engaging in behavior that is permitted by law. Now, obviously, they can't show up inebriated. They can't show up under the influence, but this is something that happens. And then also political statements. People were being fired because of things that they said on Twitter or on Facebook or something like that. You have to be very careful of that, because there's now 29 states plus DC that prohibit this type of activity. Some states say, well, we're only going to prohibit it if it doesn't substantially or materially interfere with job performance. So if someone smokes a lot of pot and they are under the influence and they're not a good performer, you can still fire them for those behaviors, but it's for job performance. It's not for the marijuana consumption. And then just, you know, a New York law, they're all similar, but they're all just a little bit different because, of course, if you have a multi-state, you know, practice, things are never easy and it never is tracked state from state. So employees' right to privacy, and this is what I said, is you really want to establish that there is no right to privacy. And the concept of this is really transferred over time. And you look at, there's a combination of things. It's like state constitution, federal constitution, statutes and common law. And you look to see, is there a reasonable expectation of privacy? And if you eliminate that from the get-go, you can search anything. And that's why I want you to make sure that you're in your policies, that you are eliminating the employee's right to privacy. And if there are other things you look at is, if there was a reasonable expectation of privacy, some things like going to the restroom, changing rooms, stuff like that, there is a reasonable expectation of privacy. You don't expect your employer to have cameras in the bathroom stall. That would be unreasonable, to that expectation of privacy. And you also look to see, do you have a legitimate business reason for doing so? So when I was in house at Penny's, they put in CCTV throughout all of the workplace. That was fine on the shop floor. It was fine, in the stores, but they also did it in headquarters. And we were like, okay, but why are you doing it? And they were like, well, it's a safety issue. We're looking at it from that. That is a reasonable purpose for the business to do so. What's not reasonable is to do it in, like, we had quiet rooms, which are basically like nap rooms or something like that. If you got overwhelmed, you could go and have this sort of Zen experience in this little room. That's a private room. Nursing rooms for nursing mothers. Clearly, I don't expect to have a camera in there. So there are certain parameters around what you can't do, but common areas, lobbies, hallways, meeting rooms even, that's completely fine. So another thing that employers do a lot is they want to see, like, okay, well, we need to be able to record customer calls for, quality assurance. And you have the same sort of thing that talks about, obviously the employee is on notice then that they're being recorded. But sometimes for other things, they may not be on notice. So if you're actually recording conversations, if you are trying to access email, and I've seen this time and time again, you would not believe the things that people send on company email or on company text. And I see this because I get involved in a lot of employee investigations. It would curl your hair. But making sure that people are aware that any type of transmission that they have on an employer device is actually something that is transmittable. And then we talked about the physical workspace. You're able to put in cameras, you're able to do stuff like that. Now, what I will trigger here is there's a difference between video recordings and audio recordings. Video recordings are probably fine, as long as it's in a common area and that kind of stuff. If you were recording both video and audio, you could have a potential issue here with respect to consent. Some states require dual consent, both of the individual that's being recorded and of the individual that's actually doing the recording. Some are what we call single party consent states, which only require one person. As a practical matter and to avoid issues with the National Labor Relations Act, my recommendation would be that you do only video recording of employees if you're going to do that, and no audio. Another call, Andrew and I were chatting right before this, and he's done a lot of stuff in the employee privacy space. And we were talking about, what about Zoom calls? What is the issue with respect to recording Zoom calls? Is that a good idea? As a practical matter, I will always tell you that recording Zoom calls or something like that is probably not a good idea. Both with respect to, because I think it inhibits the employee's ability to be fully present and saying things because they're worried about being recorded and then something happening. But there's also the issue that if there's any type of confidential information, or if there is something that's a trade secret that's recorded, if it gets disseminated outside, or if it gets breached and something else gets tracked, it's just not really worth the recording to me. I think the value that you potentially get from that is just simply not there. Other issues that we were, looking at here is, why are you surveilling it? Is it for the employee's safety? Is it for consumers? Is it for your customers? Why are you actually doing this? A lot of times we mass all this data because we can, or because there's great new technology that we're rolling out. But you have to think about it as a very pragmatic perspective. Why do you really need it? What is this actually serving? So who controls the property being surveilled or searched? This is something that happens all the time. Employee monitoring of social media or internet, especially for people that are candidates, that you look them up to see, what are they saying online? There are background checks that will actually check their Twitter feeds and Facebook and everything else to see what they post about. This is really based on state common law issues. And you have to see, does what you're doing actually intentionally intrude on their, reasonable solitude, seclusion, or private affairs? Was it offensive to a reasonable person? Basically, are you monitoring this individual like a hawk? Is it because they've been recently written up and you're finding a reason to, to fire them? And practically speaking, if you have a policy in place and you're following it consistently in a non-discriminatory manner, you're not targeting people who are minorities or women or of certain races or colors or, gender or any of the things that would be protected classes under the EEOC, it's probably okay. If you're only tracking what women say about the company because you've heard that there's something that the company has done that's upset women, that's a problem. So consistency in this is really important. Again, I keep harping about this. I also do a lot of union avoidance work. A lot of times if a company is concerned that they may potentially be a trigger for a union, they will start monitoring what is the chatter that the employees are doing. A lot of times they'll be like employer groups that are on Facebook. And I'm like, please God, do not be a part of that group, because that is going to open us up for an unfair labor practice. Don't ask for access to people's social media accounts. People have gotten better about this, but I think that that's something that you have to be really mindful and careful of. Sometimes for applicants, you'll be like, hey, I need to be able to see if they have a private account. Give us your passwords for this. Don't do that. And there's laws are becoming increasingly prolific on this throughout the country to say you can't. So that's just as a matter of law, just not a good idea. Phone calls. There's also issues with recording phone calls, even if so, not the, customer calls, but actual, the employees calling somebody else, or maybe they're calling a vendor. I've seen situations where maybe there's a alleged romantic relationship between an employee and a vendor is getting preferential treatment, and you're trying to see, is this valid? So you start recording the phone calls back and forth between these two individuals. There are situations here that potentially could be problematic under federal wiretap law. And again, about that multi-party consent. So you have to be really careful about how you're doing that. I will say that even if you're GC, even if you have experience in this area, if you are monitoring, especially as part of an employee investigation for potential misbehavior, engage in either a third-party consultant or outside counsel, because what you don't want to have is this, you need it more of an arm's length transaction that somebody else is reviewing this for you. And it becomes a bit problematic if you're making employment decisions based off of what you've heard because of consent laws, federal wiretap, and other situations. So employee surveillance on the job, okay, like I talked about. Common areas, there's no expectation of privacy. You walk into a lobby of a building, you aren't expecting to be private there. Locked office where the employer has a key or the ability to access the room. So that's okay, because it's still the employer's property. It's still the employer's office. Again, video surveillance without audio is usually okay, but it needs to be pursuant to a structured policy, and you need to put people on notice about this. What is not okay? Personal effects. My purse is on my desk. The employer typically can't come in and search my purse because that is my personal privacy. They have I would have a reasonable expectation of privacy in that. What gets tricky is if you have issues where people potentially have stolen something and you're trying to search the employee's personal effects. That can be something that, it depends on the policy and what you've expressed to them. Some employers, like for example, jewelry manufacturers, have a requirement that we have to be able to search not only your physical body, but also any type that you're taking in, because we want to make sure you're not taking diamonds out with you when you leave. Employee vehicles. So this is a tricky one. It depends. And it depends, is it on employee property or employer property? If it's on employer property, even if it is their, and it's locked and it's their car, there are what we call parking lot laws. And the parking lot laws will say that even if it's on employer property, the employer can search it. And this happens a lot in like large warehousing facilities. I represent Amazon, and we have this kind of issue where potentially people have stolen stuff and it's in their car, or they have guns in their car. And that's something where you want to be able to, there's on a federal government property to be able to see, are you bringing something in that would be prohibited? You can search the individual's car. Changing areas, restroom stalls, the kind of things where if someone's going to be in disrobed or using the restroom, those kind of things, absolutely not. So that is definitely not the case. Oops. Here we go. So best practices, you need to advise the employee in writing regarding no expectation of privacy. I want that in your employee privacy policies. I want it in your handbook. I want it anywhere where the employee potentially is being communicated to. The policy needs to outline all of the areas that are controlled by employers subject to search. Tell them if you're going to be able to search, physically their body, their purses, their backpacks, their offices, whatever it is, and obtain consent to that. And usually what we do is we roll that into employee onboarding. So when they say, yes, I've checked the handbook, then they've essentially consented by checking that they've accepted the handbook. Video cameras should be visible. So this is a tricky one. You can CCTV and you're like, well, but I don't want them to see that I'm doing this because I don't want them to think that I'm creeping up on them. Well, no, that's actually, you have a better deterrent just by tricky thing that I probably shouldn't say. You can have a fake camera And you will achieve the same things of actually recording in most situations, because you start to think that you are being watched and you behave differently with that. Any room in which video surveillance is being used to post notice is best practice. Practically speaking, I'm going to tell you nobody does that. You don't really have to. It would be the very best thing to do. Be careful regarding employer provided lockers to see, who is, there are sometimes if you don't have access to it, if it's locked and you can't get into the property, that may be something where there is a reasonable expectation of privacy in that regard. Background checks. Who uses background checks for your employees? Okay, so tip for this, free legal advice for the day. Do not use background checks for everyone. Background checks need to be limited to people you actually need to know their background. And this is going to be problematic. And the best thing to do is not to do it internally. Even if you have the resources to do so, usually it's better to use a third party for this. And the reason for that is it eliminates that some information that you may have, even if you hire them, they could always make the claim, well, you fired me because you knew X, Y, or Z about me in my background check. A lot of times if you do an external party, they'll just say, yes, they passed, or no, they haven't. There's a lot of reputable vendors that can do that for you for a limited cost. It reduces your exposure to litigation, reduces employee theft and honesty crimes, workplace violence, confirms the accuracy of applicants' credentials. There are so many faked resumes and people claim that they've done stuff or have degrees or have experience at places they've never worked and never set foot in. Absolutely, you can do this. Actually check their references, check their schools if it's something, especially in the executive level. You would not believe the bullshit I've seen where people say things that they have degrees from places or they've done stuff that they haven't done. You can verify that as an employer. But again, it's always the same thing. You need to notify them in advance that you're going to do this. You have to obtain consent, especially if you are running financial consumer checks. There is specific language that has to be in the consent about that, and telling them that this could result in adverse action. We could terminate you. We could put you on a different project if you don't have actual clearance from a federal contract or something like that. So what you really need to think about, though, is if you're using background checks, or why are you doing this? Are you doing it because you need to make sure that someone is not, they don't have a sexual assault or something like that, and you're worried about them having direct contact with the public? Are you doing it because you're hiring a new CFO and you want to make sure that they haven't embezzled before? That is a legitimate reason for doing so. But consistency is really important. Don't do it just for African-American applicants. Don't do it just for women. This has to be something that is applied for the same type of positions. Again, not for everybody. Your average rank and file employee may not need a background check. It may not be something that's truly relevant. So again, I saw third parties are usually beneficial. The consent obligations differ. You have to tell them that you're using the third party and how to contact the third party if they disagree with something. State laws differ quite a bit regarding what that disclosure needs to look like. Unfortunately, if you are a national company, there's usually like 2 pages of little special consents that you have to put for New York State and California and all these other things. But you want to make sure essentially at the end of the day, it's notice and consent. So you notify them, they consent to the background check. You have to tell them if you're taking adverse action. So it's not just like, hey, we're going to do the background check. It's also, we're going to do the background check, and this is what may happen as a result of it. And the identification if you're using a third party that actually provides a credit report. So what type of information is being collected? Again, if it's consumer credit in California, Colorado, Illinois, or Washington, D.C., there's a different consent that needs to be in that. If you're looking at people's driving records or verifying their driver's license, if they actually need to be driving as part of their job duties, you can do that, but some states require specific notices. All right, drug testing. How many people drug test your employees? Okay, obviously this is a privacy issue. The timing of the test matters, whether it's pre-employment, post-employment, or if there's been an incident, someone crashes a forklift and you're trying to do some testing there to see if they're under the influence. You also need to think about what substance is being actually tested for, where the employee is located in what state, and also what locality. Some localities like City of San Francisco or County of San Francisco have different rules than the state of California does. So you need to be mindful of that. Look to see who's conducting the test and what technical standards are being used, and has consent been obtained. So other types of employee testing, can you test people for HIV and AIDS? This used to be a thing. Thank God it's not anymore. This is not applicable. It's not appropriate. So no, you cannot. Polygraph? No, you cannot. You cannot polygraph your employees or threaten to polygraph your employees. Medical or physical examinations, it depends. It's generally okay if it's something that is necessary to the job duties. If you need to have somebody to be able to prove that they can lift 50 pounds because that's part of the job duties, you can generally do so before making a conditional job offer. Post-employment, it has to be job related, and it has to be consistent with business necessity or protection of medical information as required. So that means that once you're hired, I can't be like, hey, you know, I need you to go get a full physical and make sure that you're doing something if it's not relevant to your job. So this is a tricky one. And we did this when I was in-house. Personality test. We had a HR representative that was really into personality tests and wanted to go through all of these different things to see, you know, are you an INTJ, or, you know, what are you doing? Those kind of things, because we want to see your leadership style and how do you actually lead compared to other people. And that's maybe okay. And the reason I say maybe is it has to be non-discriminatory in actual application, and there has to be a legitimate business reason for it. And the results need to be kept confidential. So it's not like, oh, well, we heard that this person leads this way. It's something that needs to be actually meaningful to your leadership to be able to do this. And obviously, if you're going to do that type of thing, make sure you're doing actually something that's reputable. I've seen some strange employee leadership tests or personality tests or psychological tests. It needs to be something that's sort of generally accepted in the community. All right, personnel records. This is especially interesting if you have a full remote workforce, because where are those records being kept if you no longer have headquarters where HR is actually keeping this information? It needs to be maintained in a secure location, available only to individuals with a legitimate business reason to access the files. So state law may govern this as far as who can access it, what employees have to do to access their files, who can inspect or copy it, and what information or records can be accessed. As a practical matter, I will tell you, keep your personnel files scrubbed as clean as you can, because if you get sued, that's going to be something that's completely discoverable. And any type of medical information you have about the employee. So another random thing to learn today, Hipaa only applies to group health plans. That means medical, dental, vision. Life insurance has a ton of medical information. Disability has a ton of medical information, but those are not protected by Hipaa. However, I would say that in your personnel files, anything at all that has medical information, you need to keep in a separate file. Keep it separate from write-ups or personnel reviews or something like that. And the reason for that is, even if it's not protected by Hipaa, there are state medical laws like the California Medical Information Act that could prohibit the employer's use of medical information. And as a practical matter, we just like to keep that separated. Social security numbers, you have to know who they are. You have to know how to, like, what taxes to be able to do. You can access that information, but don't use that as their employee ID. We've gotten better about this, but making sure that that doesn't happen, or that you're not sending out information from benefits that has their, you know, social security numbers in it. Be careful of well-meaning publication. This is something where so-and-so had a heart attack. We are so worried about them. You know, let's put together a food drive for, you know, we're going to do a food train for the family, and make sure, don't ever do that without consent. Even if it is well-meaning, even if it is something where you are trying to engender a good culture, people get upset about that. I've seen situations where somebody passed away and the family was an aunt, and they sent a sympathy gift to the person's house. And they were like, well, why did you send this to my house? I don't want everybody knowing where I live. And it's something where even if it's well-meaning, sometimes it can trigger an unusual, response. But just think about like how you're going to deal with people who apply for a job and they don't get it. So unsuccessful applicants, how long you're going to retain that information. There are some state retention laws that you need to be aware of, or federal retention laws for employment actions about how long you keep information. Check the box laws. Have you ever been convicted of a felony, or do you have any type of criminal things? Those are prohibited now in a number of states. So you need to think about what you're doing, especially on a national level, as to what you're asking applicants for. Medical information, what I say here is, be aware of alphabet soup, Hipaa, GINA, a bunch of different things here that can be problematic for you if you're asking health information. We've already covered the rest. Biometric areas, information. This is becoming a rapidly growing information of employee privacy law. Talking about retina scans, iris scans, those type of things. especially Illinois, Texas also just passed a new law on this. It's actually a revamp of a law that has come up. But basically what this requires is if you're going to be storing any type of biometric information about an employee, that you protect it from disclosure, use reasonable care, and don't sell or disclose that information. Benefits, as an ERISA nerd, I will tell you that this is rife for employee privacy concerns. Data is a valuable asset. I mean, it's something that you amass tremendous amount of information, and that is valuable. People will pay for that information. A word to the wise, don't do that with your employee information. You can provide it to vendors for them to use for legitimate purposes, so to have the life insurance. But what you don't want to have is, for example, you send over an employee census to the life insurance, and they're also reaching out to people, say, hey, we can also provide you with home insurance, or we know that you have other issues in the house. You have an obligation to make sure that you keep those secure. There are a number of lawsuits that have happened recently, Estee Lauder and some others, where employers have had a data breach with respect to employee privacy. We're really good about employers protecting consumer information. We need to apply that same standard from breach and incident response to your employee information as well. So vet your vendors, make sure that they have appropriate cyber liability coverage, that you're actually protecting the information in a secure way. All right, National Labor Relations Act prohibits an employer, even a non-unionized employer, from taking action against employees who are engaging in concerted activity for the purpose of collective bargaining or mutual aid or protection. Now, concerted activity, that means essentially that you're trying to get better benefits or better pay, or you're having employees that are, it's kind of an amorphous definition, but it's essentially that they're trying to better the workplace. If employees are doing this, you cannot basically surveil them and take adverse action on it. If someone's posting on Facebook, when I hate working for this company, you know, the wages are terrible, you can't take adverse employment action against them because of that. This protection applies only though to non-supervisory employees. If your supervisors are saying that, you can fire them, and please do, because they're not doing you a good job by, you know, demeaning the company. But you want to make sure that this applies for both unionized and non-unionized. Monitoring systems that we talked about, the surveillance, the GPS, those type of things, could result in an unfair labor charge if they infringe on the employee's reasonable right to privacy. All right, how many of you have California operations? Okay, quite a few. So you're probably familiar then with the California Consumer Privacy Act. And there was this provision that this, even though it's a consumer, that it would also apply to employees. And then they went, you know what, actually, no, we're gonna wait on that. And they just kicked the can down the road because they couldn't figure it out. As a practical matter, the California Consumer Privacy Act became effective January 1st, 2020. And this was this landmark case. It was very similar to the GDPR in the EU. And it was something that was going to have great new privacy rights for employees. And there was a partial exemption here for employees because they just were like, employers spoke up and were like, look, we're so busy focusing on our consumers, like we don't even have the resources available to deal with employees. And through tremendous lobbying, they sort of parted out the employees and made an exception that you could use employee data for any reasonable business purpose, essentially. And that was set to expire, but they've extended it. And they've extended it in a way that we'll talk about next, the California Privacy Rights Act, which is also going to come into play. And we're sort of amorphous right now. We don't know whether employee data is going to be carved out again. It also talks about, you know, what type of personal information is covered. You have to provide a notice to employees, even though there is not a lot of the individual rights don't apply to them under the CCPA at the point of collection. So whether it's when they're hired or if you're going through some sort of diversity inclusion training and you're asking people about how they self-identify, you have to notify them that you're retaining this information and what business purpose you're going to use it for. They can't ask you to delete it. They can't ask you to do a lot of other things that a consumer could, but you still have to provide that notice to employees. So what I would suggest is that if you don't have one, that you do get an employee privacy notice to make sure that the CCPA language is folded into that. All right, so the other thing you need to talk about is incident response plans. A lot of companies have tremendous incident response plans for consumers, but you forget to involve HR. And what I would suggest that you do is make sure that your incident response plan actually covers employee data as well. So personnel records, benefits records, those type of things. The HR people, you probably have more data on your employees than you actually do on your consumers. If you're using data lakes, if you're using just data repositories, you need to know what type of data you actually have. So what is the status of that, of employee applicant claims? Sometimes people will make claims, even though the CCPA allows for for consumers to ask for deletion of data or that kind of thing. It doesn't exactly do the same thing for employees, but sometimes they will ask, or if you have an employee that's also a consumer, they'll just say, delete all of my data. And you don't have to delete all of the data. You only have to delete the data that's relevant to the consumer aspect. I'm sorry, I know I'm covering a lot of material here. I'm starting to see eyes glaze over, so I promise we're going to get through it. The CCPA. So at the point of collection, like I said, you need to have this notice to employees that you're collecting this data and what it's for. Now, because a lot of people are like, well, that's fine, but I only want to do that for California. I'm not doing this for everybody. That's a business decision. I mean, you don't have to do it for any other state, but a lot of times for consistency's sake, it's easier just to provide the same notice to everybody. And also making sure that those privacy notices are routinely looked at and updated as appropriate. There is a private right of action for breach or disclosure that's the result of a lack of reasonable security under the CCPA, and the Attorney General can also enforce it. But again, it doesn't mean that employees have the right to access their information except for the laws that apply to personnel records. Those you still have to comply with. It doesn't mean that they have the right to delete information, because you'll have a lot of people say, well, I want you to delete everything. Well, too bad. I got to tell the federal government how much I'm paying you and how much has been taken out. They also can't, under the CCPA, have the right to opt out of sale of their information. So that was all well and good. And then the CPRA came up. So the California Privacy Rights Act, I like to call it GDPR light, because it's basically modeled after GDPR with a few little tweaks. It's not a full replacement of CCPA, but it establishes this new organization, the California Privacy Protection Agency. So it's not at the Attorney General anymore. This new agency is going to have full administrative power, authority, and jurisdiction to implement and enforce. Final regulations are expected by July 1st. I'll be surprised if we see them by then, but they are expected by then. And the exemption for employees are going to be at least until January 1st of 2023. At least, because we don't know what they're going to do with it. And there's a lot of chatter that they're going to do the same thing that they did with CCPA and carve out employees to allow employers to do business and keep the employees' information separate. But there are some new and expanded rights we'll talk about on the next slide that I want to make sure you're aware of, because we don't know for sure that this exemption is actually going to happen. And you need to be able to be prepared for it. So some of these other things that the CPRA has changed is it adds breach and login and passwords to covered categories, and then it has, legislative rulemaking as well. So these rights that have come out for CPRA. So you have the right to know the notice. They had that before with CCPA, that you're collecting the information and what you're going to do with it, who you're going to share it with. That's all fine and well. The right to access the information. This is going to be something that allows you to give you the opportunity to, actually see what's in the files. And you can do that already with personnel files, but it extends beyond that. So seeing what other information you've accumulated for me. Is it part of a D&I initiative? Are you tracking other metrics about me? I need to be able to see that. They also say that you have now the right to correct information. So if you have me as a certain age, or you have me as certain sexual orientation or something else, I have the right to correct that information and put the correct information in there. There is this limited right to delete. And this is something to me that is so stupid with this law, because as an employer, you can't delete someone's social security number. You can't delete certain information about them, because you're required to use that as compliance with other EEOC obligations or federal tax issues or state tax issues. This doesn't make sense for the employer population. And I think that's why this may potentially still be carved out. You also have the right to restrict use of sensitive personal information. So things about your sexual orientation, your race, other things that the employer may not be able to use that or sell that data to other individuals. And this right to opt out of sale. And sale does not mean actual selling of an information necessarily. It's anything of value that is transferred to another entity for this data. So it's money, it's goodwill, it's a discount on a premium, it is a discount on the cost of a service. Any of those things you can't do under the CPRA. Now, it's like I said, this is constantly evolving. We don't have final regulations yet, so more to come there. That's probably what I'll be talking about to you guys next year. But it's on the horizon, and I want you to think about, what does this mean for you? And even if you don't have California operations, this is going to be a waterfall effect throughout the country. I mean, you think of it just like this giant tsunami hitting California and then just splashing over the rest of the country, because Virginia, Utah, Colorado have also rolled out similar laws that are based off of the CPRA. There's a number of others that are pending or looking at right now. Most of them do carve out employee data, but not all. So what's on the horizon for this? I get a lot of questions about, well, this is a lot to deal with, to have to see what we have to do, where is the information being stored, talking, coordinating with IT, HR, a variety of different things. Are we using data lakes? What type of information do we have? Is it historical information? And I want you to think about, as a company, are you a speedboat or are you a battleship? And this is what I mean by that. A speedboat is nimble, they're quick, they can quickly course correct if something happens. Battleships, there are some companies that it takes longer to do things. There's a lot more administrative issues, or you get clunky old systems or something like that, and it takes longer to course correct. If you're a battleship, you need to be preparing now, assuming that this is going to go into effect. If you're a speedboat, maybe you can actually wait a while and see what the regulations say before you have to devote resources to this. So next steps for you are going to be seeing what information about employees do you actually have. You need a data map. Data retention policy. Your data retention policy, I promise you, especially in light of COVID, is out of date. Please take a look at your data retention policies and make sure that they are compliant with both federal law, state law, everything from OSHA and EEOC and benefits information. That needs to be updated, because especially the benefit stuff, every single one that I've seen has been wrong in some regards. So make sure that you're actually getting counsel to review that with you. Contract reviews, where you're actually promising you're going to do something about data, or how you're going to hold data, or what your protections are going to be. Make sure that that's consistent. And look to see, how are you going to address requests? If an employee says, I'd like to access my data, maybe you don't have to do it, but maybe you want to, or maybe you want to provide them with a limited data set rather than their entire file. And then making sure your policies and procedures are up to date. And you need to have a trained response team, which may be internal. You could use external vendors like Big ID or OneTrust or somebody like that to set this up for you. But you need to have that contract in place and have it ready as to what your plan is going to be. Again, if you're a battleship, if you're a speedboat, you can kick this down the road a little bit and wait. But that's sort of where you need to be. And that's it. I feel like I've been an auctioneer. And what I will say is, employee privacy is something that is continuously evolving. Please make sure that you're reviewing your policies, especially in light of COVID, and making sure that it's something that is truly responsive to what your population is. If you have any questions, feel free to come up and chat with me afterwards. I'm happy to chat with you, or I can send you some tips about what to do. I'm never, having been in-house, I'm not going to spam your inbox with a bunch of stuff you don't need, but if it's something that's helpful for you, I'm happy to do so. And make sure you please do send in to the ACC, just your reactions and responses to this. We want to make sure that the programming is something that's helpful to you. And that's it. I appreciate all your time and attention.